So I want to welcome everyone to the guest speaker program of the US Asia Law Institute at NYU School of Law. I'm Catherine Wilhelm. This is the latest installment in an occasional series we've been holding this year called Taiwan Legal. And what we're doing is examining the legal status of the self-governed entity called Taiwan, or the Republic of China. As most people know, Taiwan is often in the news because it's seen as a possible flashpoint for armed conflict between the United States and China, which by almost any definition would be devastating. Most people know that China claims Taiwan as part of China, and it rejects any proposal for Taiwan's permanent separate existence. It views the status quo as temporary and responds forcefully or angrily to any action or statement that seems to suggest that Taiwan has a separate statehood or other separate legal status. But I think many of us are a bit hazy about the actual legal basis for China's claims to Taiwan. In addition, China actually has interactions with Taiwan, including with the Taiwan government, in the legal sphere. And these have not been widely observed or studied or discussed by scholars. So to address all of this today, we have invited Professor Ling at the University of Sydney Law School. He's Associate Director of its Center for Asian and Pacific Law. And he is going to answer the question that we pose in today's program title: what does PRC law say about Taiwan? He will explain the domestic law of Taiwan as it relates to, the domestic law of China as it relates to Taiwan, as well as how China understands and applies international law in its claims with respect to Taiwan. Professor Ling was trained in China. His first law degree was from Peking University, and he has an LLM from the University of Michigan and a diploma from the Hague Academy of International Law. Among other subjects, he teaches Chinese law and has written extensively about the legal status of Hong Kong and the relationship between Hong Kong and the PRC. So in earlier episodes of this speaker series, we have addressed the questions: what does US law say about Taiwan? What does international law say? What does the UN say? And what does ROC law say about Taiwan? You can find recordings for all of those talks on our website. So now I'm going to hand the mic to Professor Ling. He's going to provide an overview, and then as usual, we'll go to discussion and Q&A. And as you listen, feel free to post your questions in the question and answer app within Zoom, not in the chat app, please, but in the Q&A one. So Professor Ling, would you like to begin?
Thank you. Thank you very much, Catherine. It's an honor to be here to address this very important topic. Now, let me first make two preliminary points of disclaimer. Obviously, I don't speak for the PRC government. In fact, I'm pretty sure that the Chinese government would oppose quite strongly some of the things that I'm going to say today. And also, I'm offering legal analysis today. What I consider to be legally correct is not necessarily politically desirable. All right, I'm going to deal with three topics today within the limited time of my initial presentation. There are three topics I want to address today. First of all, I'm going to talk about the One China principle, which is the fundamental undergirding principle of Chinese law and policy on the question of Taiwan. Secondly, I'm going to talk about the anti-secession law, which is the main statute in China dealing with the Taiwan question. And thirdly, I'm going to talk about Taiwan in Chinese courts, how China's judicial system deals with the status of Taiwan's law and Taiwan's government. First of all, in regard to the One China principle, many of the things here have been discussed in this series by previous speakers. So I will go through the main points pretty quickly and leaving the details to Q&As and discussions. So it is well known that China's One China principle involves three propositions, and you will see on the screen those three propositions. Number one, there is only one China in the world. Number two, Taiwan is an inalienable part of China. And number 3, the People's Republic of China is the only legal government representing the entire Chinese people. All right, so I'm going to unpack those 3 propositions one by one, but before I do that, let me just clarify one thing, and there has been confusion over the meaning of one key term in this discussion, and that term is PRC, or People's Republic of China. Now, this term, PRC, can have 2 distinct meanings. In some contexts, PRC means government, just like in the proposition 3, when it says PRC is the only legal government representing China. Now here, PRC refers to the government under the Communist Party leadership, of course. In the second sense, PRC means the state of China. It is the name of the state of China that the Communist Party gave to it in 1949. Now, so PRC sometimes means a state, sometimes means a government. The state and the government are very different things in international law. And if you confuse the meanings, these 2 meanings, you sometimes come up with flawed reasoning. So one example, if you look at the slide, one example of this flawed reasoning is to say, PRC has never controlled Taiwan for a single day, therefore Taiwan is not part of PRC. You often hear this, but this is a flawed reasoning. When you say PRC has never controlled Taiwan, you mean PRC as the government. The Communist Party has never controlled Taiwan for a single day. But in the next statement, when you say Taiwan is not part of China, here you refer to PRC as a state. You see, if you mean PRC as a government does not own territory. It is incorrect to say Taiwan is part of PRC when you mean PRC as a government. For the same reason, it will be incorrect to say New York City is part of the Trump administration. You cannot say that because government does not own territory, the state does. So even though PRC as a government has never controlled Taiwan, if you mean PRC as the state of China, of course, has controlled Taiwan since the Qing dynasty, except for the 50 years of the colonial rule. All right. So if we clarify this language confusion, look at the 3 propositions. I'll go through them quickly and just set out the salient points. Proposition 1, there's only one China in the world. Now, that statement on its face sounds quite prosaic. People will say, well, what's the disagreement? What's the disagreement over that? Of course, there's only one China. Now, what this statement really means is that in this part of the world, that is to say, the territory of mainland Taiwan, Hong Kong, Macau, and so on, in this part of the world, there is only one state, and that state is called China. So what it implicitly is saying is that Taiwan is not a state. There is one China in the world, in this part of the world. There's no state of Taiwan. So that, of course, raises the question, why is Taiwan not a state? Taiwan apparently has satisfied all the conditions for statehood under international law. Why is Taiwan not a state? The standard explanation for that is the one offered by the late Professor James Crawford in his classic book on creation of states in international law. And I have the quote from Crawford's book on the screen here. In summary, Professor Crawford argues that Taiwan is not a state because it has not explicitly declared independence. That's the reason. And that has been the standard explanation given for why Taiwan is not a state. Crawford's argument has triggered lots of commentaries and criticisms. I will just highlight 3 issues here. Issue number 1. Is there really a requirement in international law that you must openly, publicly declare independence to become a state? That's question number 1. It's a question. And you might ask, well, if that is really a requirement under international law, when did China actually declare independence? The second question is, even if there is such a requirement under international law, hasn't Taiwan already declared statehood on numerous occasions? You have all those presidential statements, you have Tsai Ing-wen and Lai Ching-te repeatedly saying Taiwan is already an independent state. You have application for UN membership in the name of Taiwan. So hasn't Taiwan already declared independence? Well, in fact, so that's the second question. The third question would be a follow-up from the second question. If Taiwan has already declared independence in various ways, how come the vast majority of the international community hasn't seen it? How come no state recognizes Taiwan as an independent state? You cannot blame everything on China bullying. Of course, China bullies some small states from time to time, but you cannot say that China bullies the United States, Japan, Germany, UK, France, all at the same time. So if Taiwan is already a state, how come nobody recognizes it? So that is the first proposition. There's only one China, and Taiwan, as it exists today, is not a state. And we'll leave the questions to later discussions. The second proposition is that Taiwan is part of China. Now, the justification for this Chinese assertion for sovereignty over Taiwan is very well known, and previous speakers have already touched on it. So I'm not going into details here. So in gist, the Chinese justification is based on three historical documents, which I sometimes call the trifecta of documents. These three documents are the 1943 Cairo Declaration, which says Japan must return Taiwan to China at the end of the Second World War. And then the second one is the Potsdam Proclamation, which says the Cairo Declaration must be carried out. And the third one is the Japanese instrument of surrender when Japan says we accept the Potsdam Proclamation. And after that, after those three documents, China physically took over Taiwan from Japan in October 1945. Now, the treaty that cedes Taiwan to Japan, the Treaty of Shimonoseki, was abolished. So based on these historical events, China argues that Taiwan is being returned from Japan to China, and Taiwan is part of China at the end of the Second World War. The rejection or the opposition to that line of argument is that there is no formal treaty that actually gives China the territory of Taiwan from Japan. San Francisco Peace Treaty only says that Japan will renounce its sovereignty over Taiwan, but does not say to whom. Now, PRC government has not officially responded to this opposition, but I would imagine that the response would be like this. First, so there are 3 points to make here. First, is there really a requirement in international law that transfer of territory requires a formal treaty? What is the authority for that? If you require a treaty or a formal treaty, how formal should it be? How detailed should the treaty be? What is the international law requirement for that? So that would be the first question. The second question, or the second response would be, well, if you do require a treaty or an international agreement, wouldn't the three historical documents somehow already constituted an international agreement between China and Japan for the return of the territory of Taiwan? The definition of treaty under international law is actually quite broad. If you have those three documents which constitute an exchange, wouldn't that already be an agreement? And the third response would be, well, if you do require a treaty, here's the treaty. What is the treaty? Well, it is the 1972 China-Japan Joint Statement. When China and Japan resumed diplomatic ties or established diplomatic ties, Japan says that in this joint statement, in paragraph 3, Japan says it reaffirms its position under the Potsdam Proclamation. Potsdam Proclamation Article 8 is about Cairo Declaration. So in this statement, Japan essentially reaffirms its acceptance of the Cairo Declaration, and that is the return of Taiwan to China. Now, just in case you are wondering whether this joint statement is a treaty in itself, in 1978, there was a formal treaty between China and Japan. It is the Treaty of Peace and Friendship. In its preamble, the treaty explicitly said that Japan and China reaffirmed that the joint statement would be strictly observed. So this treaty essentially incorporated and reaffirmed the joint statement. So if you need a treaty, here is the treaty. Now, the proposition that Taiwan is part of China now is agreed to or acquiesced in by a vast majority of states in the world. And you have also international recognition. So in the UN system, Taiwan is recognized as a province of China. And in international jurisprudence, we now have international courts or tribunals recognizing Taiwan as part of China. And ironically, in this regard, the leading case is a case which China disliked the most, and that's the South China Sea arbitration case, which referred to Taiwan as Taiwan Authority of China. The third proposition is that PRC is the only legitimate government of China. Now, this proposition is not controversial. The first two propositions are somewhat controversial. This one is not, all right? Vast majority of the states, UN Resolution 2758, United States itself, all expressly recognize proposition number three. Proposition number three is significant. When you say PRC is the only government representing China, you're essentially ruling out two Koreas or two Germanys, right? There's only one PRC, one China, and PRC represents China. And more importantly, the consequence is PRC is the only party that can exercise the rights and claims in international law of the state of China. That is to say, at this point of time in 2025, the government of Taiwan or the government on the island of Taiwan, the ROC government, is in no position to invoke things like Cairo Declaration and Potsdam Proclamation. These are rights and claims that are vested in the state of China. ROC no longer represents China, so they are in no position to invoke those rights and claims belonging to China. You can ask yourself, if the ROC government cannot rely on Cairo Declaration, Potsdam Proclamation, and so on, what is the legal basis for ROC's sovereignty or ROC's exercise of sovereignty in Taiwan? So that's, I think, it is a well-recognized principle that this proposition 3 is undisputed. It has significant legal repercussions. Now here I'm just going through it very quickly. One China principle can be invoked against other states. This is not to say that one China principle is already part of international law. I don't think that's correct. I think the technically correct way of describing the one China principle is to say that the one China principle is the basis of international legal obligations binding on other states. Those legal obligations can come out of a treaty, such as the relationship with Japan. Or those legal obligations can come out of bilateral documents. And here you will have to apply the international law doctrines of recognition, acquiescence, and estoppel. You apply those international law ideas or devices, you can argue for the vast majority of the states in the world, including the United States, China can argue that one China principle is the basis of binding legal obligations on other states. Now, here I'm going to skip a chunk of the discussions to later Q&As. Here I deal with the question of how to interpret General Assembly Resolution 2758. In my view, and I think this is also the Chinese view, the Chinese interpretation of 2758, this UN resolution that restores PRC's seat in the UN. I think the Chinese or the PRC's interpretation is generally correct. It is a little bit overstated, but it is generally historically correct. The recent efforts to criticize China is actually historical revisionism. It does not comport with the international law on how to interpret the UN General Assembly resolution. I don't have time to go into that, so I'll skip that and we may discuss it. All right. Now I'm going into this anti-secession law. Anti-secession law is a national statute. It's a national law made in 2005. It deals with the cross-strait relations. It talks about, for instance, how China should develop the cross-strait relations, cross-strait exchange, what would a future reunification, a negotiation look like, and so on and so forth. But most people rightly focus on a particular, the most important provision in the anti-secession law. All right, which is Article 8 of the anti-secession law. Article 8 of the anti-secession law talks about three circumstances in which China vows to potentially use force to achieve reunification. So those three circumstances are here set out in the on the screen, as you can see. If we just explain the language here, the first situation refers probably to a formal or de jure secession. Secession, essentially. That's the first situation. The second situation is any incident entailing Taiwan's secession. The second situation is a little bit ambiguous and broad. People generally interpret to mean foreign intervention. So, for instance, United States recognizing Taiwan as a state, or United States establishing diplomatic ties or sending US troops into Taiwan, things like that probably would constitute other incidents entailing Taiwan's secession. That's the second circumstance. The third circumstance is situations where reunification is no longer possible. That is a very wide and ambiguous provision of law. All right, so in 2022, we have the latest government white paper from China on Taiwan. And here, if you look at this, this particular passage, now, the takeaway that I would have on this important passage, which deals with possible use of force on Taiwan, is this. The 2022 white paper does not address the third situation, that is to say, the exhaustion of possibility of reunification. That is not mentioned here. So, practical purposes, I think the third situation, the third provision in Article 8, probably would not apply for now. The other two provisions are very much at work. The white paper talks about two things which would force China to use force. The first is secessionist Taiwan independence movement, and the second is foreign interference or foreign intervention. These two, well, obviously correspond to the first two situations in Article 8. Now, the first provision of Article 8 says we're going to use force if you have secession. Now, as a legal matter, I was wondering what could secession mean? In other words, what would be the circumstance that would constitute secession and trigger China's use of force on Taiwan as a matter of law, as a matter of Chinese law? Here are some of the possible situations. Obviously, an open, overt unilateral declaration of independence, that would be a secession. But since Taiwan is not going to do that anytime soon, Tsai Ing-wen, Lai Ching-te are saying there's no need to declare independence. So probably this is not going to happen anytime soon. But then, short of that, are there any other circumstances that may constitute secession and trigger Article 8 of the anti-secession law? Now, here are some possibilities. Overt secession. Now, that includes those presidential statements by the presidents of Taiwan. So far, we have already seen that China doesn't really take that seriously. Okay? Tsai Ing-wen, Lai Ching-te have made statements repeatedly. Taiwan is already independent. We don't need to declare. Well, China doesn't care. China doesn't take them seriously. So those, what you might say, covert secession doesn't seem to apply. Then the next possibility would be the change of state symbols of Taiwan. What if Taiwan changes its name? Let's say everything else stays the same. But Taiwan changes the state name from Republic of China to Republic of Taiwan. Would that trigger Article 8? We don't know. think it might. It's a possibility. What if Taiwan changes other state symbols like the national flag, national anthem, national emblem? Would that trigger Article 8? Again, we don't know. Amendment of the Constitution. If Taiwan should abolish the two provisions in the ROC Constitution that are generally recognized to be one China, would that trigger Article 8? And we know there are two provisions, that's Article 4 and additional Article 11 in the ROC Constitution that essentially follows the one China policy. Well, what if these two provisions are abolished in an amendment? Now, in Taiwan, amending the Constitution is terribly difficult. So we don't think it will happen anytime soon, but would that trigger Article 8? I think it will, but who knows? And the other more distinct possibility is the reinterpretation of the Constitution. What if Taiwan's Constitutional Court could reinterpret those two provisions of the ROC Constitution and says, well, actually, those two provisions of the Constitution do not mean we claim sovereignty over the mainland. Taiwan is just Taiwan. Well, now, of course, we know the Constitutional Court of Taiwan right now is in some crisis mode. But if they survive the current crisis and do a reinterpretation like that, what would China react? Would that trigger Article 8? Now, some years ago, I think in 1992, there was an attempt to ask the Constitutional Court to interpret Article 4 of the ROC Constitution. At that time, the Constitutional Court says this is a political question. We're not going to do that. Well, what would the Constitutional Court say in the future if the same case goes to them? All right, so that's the anti-secession law. I think I will now move into the final topic. I think I pretty much know my time is running out. So I will just address the final topic a little bit, and then I will be happy to do Q&As. So Taiwan in Chinese courts. So the official Chinese law and policy sees Taiwan as a province of China. It's part of China. Actually, the NPC, the Chinese legislature, has a Taiwan delegation, a delegation of 13 deputies representing the province of Taiwan. It's a little bit comical, but there is this delegation in the NPC at this moment. The Chinese courts actually take quite a pragmatic attitude towards Taiwan. There is a strive for normalcy, legal normalcy, in my view, on the part of Chinese courts to deal with cases involving Taiwan. So here I'm setting out two areas. The first area is that in the past 2 decades or so, Chinese courts have adopted a pragmatic position in regard to the recognition of the validity of Taiwan's laws, legal process, and court judgments. So it is possible now in China to have the Chinese courts recognize and enforce Taiwan's civil court judgments. The Supreme Court has a judicial interpretation to that effect. Supreme Court also allows Chinese courts to apply the law of Taiwan as a matter of conflict of laws in civil cases involving Taiwan. So Taiwanese law is just like English law or American law, can be applied by Chinese courts in cases involving Taiwan. And of course, China and Taiwan have an agreement on cooperation in criminal cases. So in that way, the validity of Taiwan's legal system is recognized in Chinese courts. Now, what about the Taiwanese authorities, the Taiwan Dangju, that is to say, the government of Taiwan? Chinese courts, surprisingly, also take a very pragmatic attitude to that. And the evidence for that is a case published by the Supreme People's Court at the end of last year, 2024. The case is extraordinary. The county government of Kinmen, which is obviously a county government in Taiwan, in ROC, started a lawsuit in the PRC court, in the Xiamen Maritime Court, some years ago, and I think it was 2017 or 2018. They started a lawsuit suing certain Chinese companies for causing marine oil pollution in the Kinmen waters. The Chinese court, the PRC court, decided in favor of the Kinmen County government. Right? The court essentially applied Chinese law and says, well, this is marine pollution. The polluter should pay for the cost of cleanup. Now, the court did not address the most important issue in that case, which is whether the Kinmen County government actually has the legal standing in China or in Chinese law. You see, if I'm the lawyer for the defendant, the first thing I'm going to argue is this Kinmen County government? They're not organized under the PRC law. Under the PRC legal system, this county government simply has no legitimate status. They should have no standing or the legal status to bring a lawsuit against us. Well, that was not addressed by the court. We don't have the full judgment of the court. The full judgment is not available in the public domain, so we don't know. But the Supreme Court apparently thinks this is a very good judgment. They published this case as a typical case, a 典型案例, and they released the case in the news media and published to the whole China. So if you look at this judgment, at least Chinese courts implicitly recognized the de facto existence of a Taiwan governmental body. And that, I think, is important. So in summary, I think Chinese courts, when dealing with Taiwan, Taiwan's law, Taiwan's governmental entities, Chinese courts, despite the one China principle and one China law, has adopted quite a pragmatic attitude in dealing with criminal and civil cases. I'm sorry, Catherine, I know I have way exceeded the time allotted to me. I'll stop here for now, and I'm open to discussing all these issues with you and with the audience. Thank you very much.
Well, it's extremely easy to forgive you because it's been fascinating, and almost every part of your exposition I've been eager to hear more. So I want to actually start with this last topic that you brought up, this Taiwan and Chinese courts, even though I think we'll go back to your earlier points about the larger issues, but because this is so fascinating, as you say, there is a clear inconsistency, right, between the Chinese court accepting the Jinmen County government as being an entity that has sufficient legal personality to be in court as a plaintiff. There's a clear contradiction. Why do you think they did that? Should we assume that they reached out to the provincial court first to say, to look for guidance, or even higher to the Supreme People's Court or beyond to look for guidance before doing it? Do you think that this whole case was part of a diplomatic strategy to show some kind of an attitude of legality and reasonableness to the Taiwanese people? Because then, of course, it was publicized, as you point out. So was this whole thing kind of set up?
Yeah. Now, the case published in December 2024 was a batch of 4 cases, which the Supreme Court published as a batch of typical cases, called Typical Cases on the Protection of the Legal Rights and Interests of Taiwan Compatriots. So this, in a broad way, this comports with the larger PRC policy, which is, even though we fight Taiwan independence, we're going to promote cross-strait exchange. We're going to protect the rights of Taiwanese and the Taiwanese companies, and even the Taiwanese government bodies. So politically speaking, I think the Supreme Court is pretty much following this party policy. Not legally speaking, this position of the Supreme People's Court, in a way, is most reasonable, and in fact, it would not be a surprise for most lawyers in other countries. In the common law system, for instance, there is a clear line of jurisprudence recognizing a government body that has not been recognized by the state. So even if we haven't, our government has not recognized a particular government body, that government body and its laws can very well be given effect in our courts. So, for instance, you have English courts giving some recognition to the East German authorities at a time when Kingdom did not recognize East Germany either de jure or de facto. This is all because of common sense, because of maintaining the normal civil and commercial order. So in that sense, I think the Chinese court is showing practicality, the pragmatism, and the reasonableness. So I would say, in this dark time in cross-strait relationship, this is a ray of light, which I hope can be amplified in the future.
Have any, to your knowledge, have any mainland government agencies filed any kind of claims in the courts of Taiwan?
I checked, I searched the database, and I talked to colleagues. It seems that this Kingman maritime case is the only case in which the government of mainland or Taiwan filed a lawsuit at the other side. So far,
Okay.
this is the lone case.
I see. So now it's up to Taiwan to decide if they want to extend the same courtesies. And just another quick aside, when Taiwanese appear in court as plaintiffs, or for that matter, as defendants in mainland courts, as I'm sure they do frequently because of the extensive trade and commercial relationships, and also a lot of blended families. So there must be inheritance disputes, divorce disputes, etc. Are they treated as foreigners, or are they treated as Chinese citizens? Because in many instances in mainland law, when a law defines certain behavior towards foreign entities, Hong Kong and Taiwan entities are included in the Jingwai and in the foreign side. So what happens in courts where they're plaintiffs? Are they Shuai cases, foreign touching cases?
Mm. I think as a matter of law, they are not sure why they are not considered to be foreign entities, but de facto, uh, all those all those beneficial policies, tax benefits, and so on that are afforded to foreign investors are also afforded to investors from Taiwan, Hong Kong, and Macau. And as I mentioned, when a Taiwanese company or individual have a conflict, have a dispute with the Chinese entity, the case is often is treated as a Shuai case, and the private international law rules will apply, and the law of Taiwan can very well be applied.
Interesting. So, but let me go back to the main question, which is Taiwan's status. And I wish, in a sense, that we, of course, had all of our speakers together. And then some of our earlier speakers could respond directly to the arguments you've made, because you've raised a lot of counter arguments directly to the arguments they've already made. You've had the advantage of seeing what they've said, and so you've been able to respond to that. I think what I'll just mention for the audience that the plan at the Institute is to summarize in writing some of this material, and in writing at least, to sort of line up side by side what the various perspectives are, since we're not able to do it with the speakers all together on one screen or in one room, unfortunately. And the goal also is not so much in any individual session to sort of debate or refute the arguments, as much as it is to lay out very clearly what is the argument and make sure that we fully understand on its own terms what it is that the PRC argument is, so that we can then consider, does this make sense? Is this a strong argument? So having said all of that, what do you think is the PRC's strongest legal argument for having a legal claim under international law to the territory that is Taiwan? So they argue, of course, the longstanding history of past administration. thousands of years even. They argue that Shimonoseki was either an invalid treaty was it 1894, at the end of a war with Japan, or even assuming it was valid, that the ROC that China then abrogated it at the start of hostilities in the 1930s when Japan went to war basically on the territory of China, and further that it was, that Japan, gave up any claim at the end of the war, and that when Japan did give up its claim and surrender to Chinese authorities on Taiwan, and in its instruments of surrender to the Allies, Japan said, we surrender our claim to Taiwan. We accept the decisions made in Cairo and Potsdam. So all of that is kind of the package of arguments that China makes. What part of this do you think is actually the most strong as a matter of international law? Is it the history part? Is it the body of textual documents, which I think for the American government tends to focus a lot on the texts in their arguments and what is missing from the texts?
Right. Obviously, this is not going to be something that will be heard by the International Court of Justice. We can talk about the role of international law in broader politics in this a little bit later. But in terms of the strongest points that China makes in regard to Taiwan, I think I would just point out the following three things. I was thinking about three things, but let me just see if I still remember. The first point is the fact that so the first point is that the reliance on the historical documents is something that both PRC and ROC shared. So ROC, up until the DPP government took power, essentially argued exactly the same thing as PRC. So they also relied on the trifecta of historical documents and so on. So the fact that PRC and ROC both use those arguments to say that Taiwan is part of the state of China. In fact, the ROC representative in the debate before the resolution 2758 makes exactly that point. He says Taiwan is part of China. There's no dispute about that. Well, that's, I think, one thing that is very favorable to the PRC's position. That's number one. The second point I think PRC is very strong at is international recognition. It is the recognition by the majority or large majority of the state, by the United Nations, and by international institutions. That, I think, plays very strongly in China's hands. So that is the second point. What is my third point? Right. So I think, well, it will come back to me later. So I think when you look at the international law issues, there are some important arguments that China can make, and China sometimes may not be able to articulate some of those international legal arguments well enough, or in a way that is persuasive enough. But I think overall, there are historical legal materials that are in China's favor, which China can rely on. But at the end of the day, international law has a limit in terms of the role it can play in settling this dispute in the long term. So that probably is another matter that we can look at.
Well, exactly. I mean, if this were to go to the ICJ, then we would have learned justices telling us, how they line up the competing arguments and understand them. That's not going to happen. But the arguments about, it seems to me that sometimes we combine two separate issues when we're talking about Taiwan and its status and its what it is and is not entitled to. One is the territory of Taiwan. Is the territory of Taiwan part of this larger entity called China, the state of China. The other is, what about the fate of the people of Taiwan and the society of Taiwan and this whole society? So it is one thing to argue that the territory of Taiwan was given up by Japan either to some government of China or it reverted to the state of China. That's one argument that, yes, is disputed, but that you could make. It's a totally different thing to say that the China, the PRC, has the right to take by force the island and its people, the whole society, and to engage in armed conflict against a thriving, peaceful society that is not actually engaged in armed conflict against it. So how to address that difference, that's a different argument. And it strikes me that even if all the jurists and scholars in the world were to say China's right, it has if you will, it has the deed to Taiwan. The deed to Taiwan, the real estate, is not the same as the right to invade and attack society.
I think the political and moral force behind this argument against the use of force is incontrovertible. I think the PRC's position is also that the use of force is not something that they are going to consider lightly. In fact, the 2022, the most recent white paper makes it quite clear. In fact, it uses this explicit language saying that this is going to be our very last resort. So that on that, I don't think the PRC government would disagree with you. Now, on the question of people, I think I have argued in relation to Hong Kong, for instance, that you cannot just apply the traditional international law to territory as if they are vacant of population. There are people living in that territory and who have their rights and who have their interests. So now, this is the part that I want to emphasize, the importance between legal analysis and political or policy arguments. International law at this stage, you only need to look at the situation of Catalonia in Spain in 2017. And you can see that the majority of the will of the majority of the population in a particular territory to want to have an independent state is not often given weight in international law as it exists currently. I think international law still is quite clear that there is no legal right of secession. International law does not prohibit secession, but there is no legal right of creating an independent state against the will of the central government. So that means we need to have a political process. We need to have a political process to remove the danger of use of force. And I'm sure we can talk about that maybe a little bit later. But for now, let me just say the vast majority of Taiwanese people are in favor of status quo. The optimal status quo, in my view, is the one characterized by President Ma Ying-jeou as the three no's. No reunification, no independence, no use of force. That, I think, remains the optimal status quo for mainland China and Taiwan. But unfortunately, we seem to be moving farther and farther away from those three no's right now.
Catalonia is an interesting case. Does it matter, though, what the starting point is, right? So if in Catalonia's case, they are currently under the administration of Spain, they are already part of Spain, as it were, and they're seeking to break away from the control of Spain. So that makes it very hard for them. Taiwan is not under the control, the actual administrative control or military control of China. So the status quo is actually the inverse, So is there some kind of a analogy to a physical principle of favoring the keeping of the status quo, whatever it may be, so that maybe for the people of Catalonia, unfortunately, they are in a position where they can't get out from where they are, but the people of Taiwan happen to be in a position where they are already separate. So I wonder to what extent that might change the analysis. It occurred to me, and perhaps this is a little bit far out, but I'm going to suggest it anyway. If one thinks of, we frequently hear the phrase that Taiwan is a breakaway province from China. So the assumption then is Taiwan is part of this larger entity called China, and it is on the periphery there saying we want to peel away. But if we look at it from a chronological perspective, Taiwan, the government of Taiwan, the Republic of China, to make the distinction that you keep and correctly have made between governments and states, the Republic of China was the government of a much larger entity. Rather than the Republic of China trying to break away from the PRC or from China, if we start from the perspective of thinking of the Republic of China having simply lost 95% or 98% of their territory, they are what remains of a state. Then I think the perspective about who is the breakaway party shifts and who is the acting party shifts. They are simply persisting. Nothing has changed on the island of Taiwan. They continue to exist in their prior state as they are part of the Republic of Taiwan. Of China in Taiwan. Nothing has changed for them. So now the acting party, the one that has broken away, is actually the larger chunk. Does that change anything in the analysis?
Well, that's a way of looking at things, but I think international law, and I think it's recognized by most states around the world, that what happened in the late 1940s with the civil war in China. You have two competing governments, the communists and the nationalists, and it turns out the communists won the war, controlling 98, 99% of the territory and the population. Civil war usually ended quickly, but in this case, it's just never ended. So now in that situation, there is logically or legally, there is no inevitability in saying, well, if you have two governments standing side by side within the same state, other states possibly can recognize both governments, even though each government claims sovereignty over the entire territory. That's legally quite possible. There's nothing wrong with that. It has happened with two Germanys and it has happened with two Koreas. But in China, it's not possible because the PRC and ROC for a while insisted that you must recognize only one government, right? One is the king, the other is the bandit. And other states went along. So that is the third proposition in the One China principle. You must recognize PRC as the sole legitimate government of China. And when you do that, a vast majority of states have done that. The United Nations has done that. When you do that, then you are essentially ruling out the legitimate status of Taiwan in international law. And that I think plays very well into the Chinese hand, and I think that probably is one of the most important and strongest points that China could make.
Yeah, it does seem clear when you look at the history that one of the that historically moments at which a political resolution could have been reached were passed up by one side or the other or both sides. And to some extent, the problem is one in which everybody had a hand in digging the hole deeper
Yeah.
at every possible opportunity. So let me look at some of the questions that have been posted. And one of them is from your friend and colleague, Professor Fu Hualing, Dean in Hong Kong University, he asked, how does the one China, two systems paradigm fit here? And Hong Kong, of course, is the example of one China, two systems in practice. Deng Xiaoping famously created this model, this proposition for the reunification of Taiwan with China, but that didn't happen, and instead Hong Kong was brought back from from Britain in 1997 to China using that model. So how well does that model, and you're quite familiar, I know you've written about one country, two system, how well would the model fit with Taiwan as things currently exist, today's Taiwan?
It's not promising. I think the overwhelming majority of people in Taiwan reject the one China, two systems model for Taiwan. Obviously, people in Taiwan were skeptical at first, but what happened in Hong Kong, especially following the implementation of the national security law, seems to cause people to even have less confidence in how this model can apply to Taiwan in a way that can preserve the rights and freedoms, the way of life of Taiwan. I think one thing that happens in Hong Kong that makes the one China, the one country, two systems model less and less palatable is because when it starts to be implemented over the past 2.5 decades, the Chinese government, the mainland government, started to interpret this policy more and more in favor of the central power. That tendency is very clear. It started, for instance, in the government white paper on Hong Kong, in which it argued that the central government has the so-called overall jurisdiction or overall governance, the overall governance power in Hong Kong, even though it is not written in the Basic Law anywhere. And then, of course, in 2020, they enacted the national security law, even though the Basic Law itself says quite clearly that national security law ought to have been made by Hong Kong. So when mainland China, the central authorities, of course, has their own reasons for doing that, but when they did that, gradually expanded the central government power at the expense of Hong Kong autonomy, it inevitably will have impact on how people in Taiwan would look at the one country, two systems model. So I think at this moment, and probably for the foreseeable future, the one country, two system as a model for Taiwan is dead. This is not going to be something that can be a shared framework, so to speak, for any negotiation between mainland and Taiwan. Mainland and Taiwan authorities will need to find something different. That would be my view.
And is there anything that you see as a possible entry point for that something different? One person I'll just add here had a recent interesting conversation with a Taiwanese American lawyer who suggested that she thought there might be room for some kind of a rapprochement if there was a clear effort to keep other parties, other countries out of it. In other words, that one of the factors that that Beijing is most concerned about and sensitive to, and you certainly see this in their white papers, is the role of the United States. I mean, in Beijing's eyes, the United States is the author of this whole dilemma. And so, and if there were some kind of agreement in which no other states played any kind of a role of any kind, and it was understood or agreed that they would not have the right to bring in forces of any kind, that then, the two sides across the strait could reach some kind of an agreement between themselves. That was just one example of one person's theory.
Yeah. Well, I'm not an expert in in political science, so my view would be one from a non-expert. But the way I look at it, well, first of all, the U.S. Six assurances for Taiwan includes one that says United States is not going to mediate between Taiwan and China in any future negotiation. Now, Trump doesn't really feel bound by anything, so he may just disregard the six reassurances and play a mediator role. Who knows? Let's step back a little bit from this. Mainland and Taiwan need to talk. We need to negotiate. The current status is far from optimal, right? The current status is dangerous. At any time, we have the risk of some incidents that can causing catastrophes. It is not optimal. So they need to talk. But in order to talk, you need to have a shared framework. I think this is what international relations theorists call an intersubjective understanding. That is to say, an understanding that recognizes the legitimacy of each other's narratives. Now, the 1992 consensus used to be such a shared framework, such an understanding. Now we don't have that. All right. Now, I personally would blame it on Taiwan. It is the DPP government, when they came to power in 2016, withdraw that understanding from the cross-strait relations. But Tsai Ing-wen and Lai Ching-te have not been able to put in anything as a substitute. All right. So since 2016, we don't have any talk. We don't have any dialogue. Taiwan was not able to provide anything that mainland could agree to. Now, I think Biden's repeated assurance that the United States will come to Taiwan's rescue in case of armed attack, what I think gives Taiwan a false sense of security and a lack of urgency. What I think the Trump administration, the impact of Trump, is that since Trump, this transactional, the volatile nature of the Trump policy might mean that Taiwan will take this matter urgently. That we now may have a possibility of mainland and Taiwan thinking about the situation from afresh and hopefully at least trying to find a common understanding, a shared framework. United States, there have been discussions in the literature about the United States possibly striking a grand bargain with China at the expense of Taiwan. This, I think, is becoming more and more possible with Trump's transactional policy, which should ring a significant alarm in Taipei. And that, I hope, will put pressure and put urgency, the sense of urgency, into the DPP government and to take steps and try to find a way to restart the talk.
Yeah, it's interesting you mentioned the 1992 consensus because it seemed that that was flawed by the secrecy of the discussions that were held at the time, right? I mean, there was no statement at the time of what the alleged consensus actually was or what the two sides were saying they had a consensus about, right? Very little actually came out. It was a closed door meeting. There was no joint communique or anything like that at the end of it. And then at some point, and I believe, if I'm not mistaken, this actually, our prior speaker, Chen Yujie, discussed this in one of our earlier series, but if I'm not mistaken, it was actually several years later when the narrative came out that the two sides had agreed that there was one China, but they had separate interpretations of what that one China was, right? And so the consensus in that narrative was a consensus that that there was some kind of a one China, but with their separate interpretations. But that wasn't something that both sides actually said at the time. And so the DPP's problem seemed to be that they didn't actually believe this was a genuine consensus. Their argument is, as I understand it, there actually wasn't a consensus. There was a photo op. Right. There was a show of a consensus without there being a real consensus.
I think this so-called 92 consensus, which is one China, different interpretations, 一中各表, uh, even even if it is reduced to a piece of writing and both parties signed it,
Mm,
it would still be something that is intrinsically ambiguous. But
mm,
it remains true that this piece of paper or this idea of 92 consensus serves as the working basis for cross-strait cooperation for 8 years under Ma Ying-jeou.
mm,
And Tsai Ing-wen, when she first, in her first inaugural address, she said she respected this fact of 1992, the both sides seemingly agreeing to something.
mhm,
So she made some apparent concessions on the 92 consensus. But in the end, I suppose for reasons of domestic politics, uh, uh, the DPP government never embraced the 1992 consensus. And that is unfortunate. And without that, I mean, right now, I don't think there's any possibility that DPP would agree to 92 consensus again. So 92 consensus probably is dead as well.
mhm,
But that means we need to find something new. Uh, what is it? Could it be some sort of provisional pledge, let's say, like the situation in Hong Kong for the next 50 years? We are not going to declare independence and you are not going to use force. Can we have something similar to that? Something that both sides can at least consider. Right now, we don't have that. And
mhm,
perhaps we need third person to mediate, a third
mhm.
person with gravitas. Uh, I don't know, but right now it's just unfortunate that China is raising the slogan of reunification. Taiwan, in the eyes of China, is moving farther and farther away. And of course, this danger of use of force seems to be looming all over us. That uh, that's not good.
Yeah, I'm a bit alarmed that you pointed out that the most, because I had not realized this, that the most recent white paper does not mention one of the well, I was in the anti-succession law, as you pointed out, there are three possible triggers for use of force, one of them being that the possibilities for peaceful reunification should be completely exhausted. And you say the latest white paper in 2022 does not mention this. So are you understanding that to mean that that even if possibilities for a peaceful reunification were not exhausted, any sort of quote major incident, whatever Beijing might deem to be a major incident,
Mm,
could trigger use of force that Beijing would not feel it could not use force, even
mm.
though
Well,
there,
mm,
some theoretical possibility for peaceful unification might exist.
yeah, well, uh, So the three circumstances for use of force in Article 8.
Hmm.
Uh, I'm sometimes asked by my students, why do you pay attention to Chinese law? I mean, China is not a country of rule of law. Chinese Communist Party would not pay attention to the law if it wants to invade Taiwan. I mean, in a sense, that is true. But the law, the anti-secession law, the white paper, they at least give us information about the thinking of the Communist Party, their policy preferences in regard to Taiwan. So we need to pay attention to what they say. So the latest white paper talks about use of force if you have Taiwan secession and you have foreign intervention. That I think corresponds with the first two circumstances, secession and major incidents. Major incidents involving, it could be U.S. recognition. It could also be, for instance, Taiwan acquiring nuclear weapons. That could also be a major incident. Now, the third situation, which is exhaustion of reunification possibility, well, that as a matter of legal analysis, you might say, well, if you're going to invoke that provision, you probably need to give notice first. You probably need to say, oh, we think the possibility is receding very quickly. We might
Mhm.
invoke. Well, of course, that's a legal analysis. I don't think the Communist Party will pay attention to that. But I think it is significant that the white paper says nothing about, oh, we are losing hope. We don't think reunification is possible in the near term. I mean, the white paper seems still hopeful that we are making progress and reunification is our ultimate destiny and so on and so forth. So that's my reading. I don't think this third provision needs to worry us for now. Uh,
Mhm.
we can just focus on the other things that the white paper warns us about.
Mm. One member of the audience points out that President Xi Jinping of China has said that the Taiwan question should not be passed or cannot be passed from generation to generation endlessly. Um, so there is some sense of there being some kind of a timeline in their mind. And of course, as you know, some US officials, particularly military officials, have come up with what they believe are, through interpretation, what they believe are deadlines that have been set by the Chinese leaders in various forum where they've seemed to say that they have to be ready by this date or that date. What is your sense about these different timeline scenarios that are put out there?
Uh, well, there haven't been a publicly announced timeline or deadline.
Mm,
And why would China do that, right?
mm,
Uh, you keep the deadline under wraps, works to China's advantage. Now, I think Xi Jinping clearly has a sense of urgency in resolving this problem. But would that go as far as using force against Taiwan? I think so far at least I don't see clear evidence for that. This is now becoming a major issue on the policy agenda of the Communist Party and Xi Jinping. There's no doubt about that. Uh, but is the use of force inevitable, or is the use of force imminent in 2047, as the U.S. reports, some of the U.S. reports are saying? I don't see evidence of that, and uh, again, the situation are ominous. Lai Ching-te has declared mainland to be a hostile force. And if we look at the United States, I think, Catherine, you mentioned there were about 40 bills before the US Congress regarding Taiwan. And I took a look at this, and I sometimes have the feeling that some US congressional people might want China to start attack on Taiwan. It almost give you that impression, because many of those legislative proposals would involve or would constitute what China might consider to be US intervention into Taiwan.
mm,
So again, I mean, I think we need to needs to calm down and start to talk and start to think about how to start a realistic a process of realistic negotiation, rather than just fanning up the emotional sentiment and increasing the tension. That unfortunately, this does not seem to be what is going on right now across the Taiwan Strait.
There's a question about the One China principle, and I want to go back and look at your first slide, or was it the second? You said the One China principle has three propositions, three elements. There's only one China in the world. Taiwan is an inalienable part of China, and the PRC is the only legal government representing the entire Chinese people. What does it mean to say the entire Chinese people? And
Well,
this question, I think, is partly caused by increasing talk from Beijing about civilizational claims. You know, the Chinese civilization, and that the current government represents the Chinese civilization, and China is a civilizational state. This tends to make people on China's geographic periphery feel a little nervous because it sounds, when you are the rightful ruler of a people or a civilization, it sounds a little bit divorced from hard boundaries. So it almost sounds as if China's saying, well, we have the right to control, to govern Taiwan because they are ethnically Chinese. And if that's the case, then they also equally have the right to control Singapore because it's largely ethnically Chinese. And there are other communities in the world that are heavily ethnically Chinese. So what is your understanding of that?
Uh, this version of the One China principle, as I put on the slides, uh, comes from the 2000 white paper of the Chinese government. It uses these words. It is obviously a political statement. As a matter of law, the government represents a state. Uh, whether the government represents all people or the ethnic people of a particular country, that's not really a legal matter. Now, as a policy matter, China historically, in its overseas Chinese policy, in its policy to Taiwan, Hong Kong, and Macau, does sometimes claim leadership, claim to be the, the pioneer force for all the ethnic Chinese people. And they have political or moral expectations of Chinese people to act in a particular way, basically, to support China in its national reunification cause. Uh, that has been the Chinese thinking for decades. And I think you are quite right that this idea, this ultra-nationalistic sentiment is behind the One China principle. But coming to the matter of law, I think when you look at bilateral statements between China and the US, if you look at 2758, the resolution, it all talks about recognizing PRC as the sole legitimate government for the state of China, which is what international law would envisage. Whether you represent the whole people, whether you have special rights or special interests in terms of ethnic Chinese, especially for those who are living outside, it's quite a different matter. Now, we do see, for instance, Russia claiming special rights over overseas Russians recently. Not without precedent. But how far China will go, especially if Chinese action is at the expense of the sovereignty and the legal order of other countries, that remains to be seen. China is or has been more and more proactive in this field, which is disturbing.
You mentioned Russia, and I'm glad you did because I wanted to ask you about the extent to which Russia's stance via the Ukraine, its claims with respect to Ukraine, may be trying to stretch international law to legitimize its actions, what the implications of these are for China via the Taiwan. Now, I know many people have talked about the example of Russia taking Ukraine as as possibly setting an example of what is possible. If you want a piece of territory, just go for it, grab it, because the world community is not unified enough to really push you back. So that is certainly one powerful way in which the Russia-Ukraine example has possibly affected the China-Taiwan discourse. But there is this other more subtle way in which Russia's arguments about its rights via the Ukraine could also carry over into the China-Taiwan context. Are there ways in which you see China now using some of the same language as Russia and applying some of the same arguments as with respect to international law?
Well, I think the Russia-Ukraine situation clearly presents a mixed bag for China, and the Chinese position has been ambivalent. This bottomless friendship rhetoric happened actually before Russia invaded Ukraine, and since then it has never been repeated. The Western governments and Western media often repeated it, but the Chinese never repeated it in its official documents. Now, China has not recognized, for instance, the annexation of Crimea. China has not recognized the Russia's territorial claim in Ukraine. China supports Russia in the war, but China does not say that the Russians' use of force on Ukraine is legal or lawful. You might infer that from some of the Chinese statements, but at least the Chinese government officially has never confirmed the legality of the Russian invasion into Ukraine. So what Russia has been doing, especially the way in which Crimea was annexed by Russia, might cause some worries in Beijing. The fact that you have a referendum in Crimea declaring independence from Ukraine and then joining Russia, that is a double-edged sword for China as far as Taiwan is concerned. But what I think is encouraging for China is this split public opinion in the world, especially in the global south, in terms of this clearly blatant violation of international law by Russia. If China should use force on Taiwan, God forbid, any excuse, China could well expect the world to be even more split. You might not even be able to get a General Assembly resolution condemning the use of force on Taiwan. Forget about Security Council, of course. So I think that would be encouraging for China. And if China's use of force on Taiwan is because Taiwan somehow makes a secessionist move, it might attract even more sympathy from the world public opinion. So it's a mixed bag for China. China has to constantly adjust its policy, its diplomatic postures. I think this is a delicate matter for China to handle.
Mm. The referendum question is an interesting one as well. A referendum is calling a referendum or plebiscite is one of the actions that I believe is specified in the anti-secession law, is it not? As one of the, or maybe it's in the opinion that was issued last year by the court, and the other ministries on how to apply the anti-secession law and the criminal law. And calling a referendum or plebiscite of the Taiwanese people on the question of sovereignty or of statehood or independence for Taiwan is deemed one of the actions that would constitute a criminal act, right?
Yep.
That is quite striking because, of course, it seems to go against, again, international laws and principles of self-determination. As you pointed out, international law doesn't favor allowing people to decide in every circumstance whether they get to be part of the state or independent. But do you want to talk a little bit about criminalizing holding a referendum and some of the other things that are criminalized in that interpretation?
Yeah, so because of the One China idea, Chinese criminal law, in theory, could apply to the entire territory of China, which would include Taiwan, well, from China's point of view. So there is this crime of secession under Chinese criminal law for many, many years. Potentially, it could apply to Taiwan, but it was never explicitly made so until 2022, when China issued this so-called opinion about the punishment of the crime of secession. What it did was that it set out several specific acts, and one of them was the organizing of a secessionist referendum. Well, to be clear, it's not any referendum. It is referendum for the purpose of secession. That would be one of the specific acts that was criminalized under that opinion. The other thing that the opinion said, and this is based on an amendment in 2018 of the Chinese Criminal Procedure Law, which is criminal trial in absentia. All right. So the in absentia criminal trial was introduced in Chinese law in 2018. In 2022, this particular opinion says we're going to apply it to Taiwan or to crimes of secession. People who in Taiwan do these things can be tried in China in absentia if evidence is straightforward, if evidence is clear. Now, so far, I don't think China has done that. It is mostly symbolic, obviously, and it is, I think, part of the strategy of the Communist Party to put pressure to counteract what China perceives to be this increasing secessionist move. Now, if we already have cases in which China has arrested and put on trial certain Taiwanese individuals, especially those members of the DPP. So it serves as deterrence. I don't think as a practical matter for Taiwanese politicians, as long as you don't go to China without assurance of immunity, I don't think it will have practical impact. It is mostly symbolic, serving as a general deterrence.
Well, the anti-secession law, though, does seem to broaden the obligations out to ordinary people. Well, it says that all Chinese, including all people in Taiwan, have certain obligations and duties with respect to working for unification and being barred from supporting secession, even joining an organization that supports secession, or making statements in an official capacity. So a teacher in a classroom making a statement deemed to be in support of secession could be said to be in violation of the anti-secession law, could they not?
That could be so under the 2022 opinion. The opinion did criminalize promotion of secession in areas of education, culture, news media, and so on.
This is quite terrifying, I would think, for ordinary, not just, people who are in government officials, but ordinary professionals who might, in the course of their duty, either their writing or their teaching, say things that could be construed to be anti-secession simply because they are not endorsing the One China principle.
Well, in theory, yes, and it is magnified by the introduction of this in absentia trial. As a practical matter, as I always tell my students, Chinese criminal law can apply to all Chinese nationals worldwide, wherever you are. And in fact, even if you are a foreigner outside China, if you do something against China's national security, in theory, Chinese criminal law can apply to you. But as a practical matter, I actually have searched the Chinese court database on this point. There have been very few cases in which actually foreigners or non-Chinese have been prosecuted for something that is done outside China. Most of the cases relate to drug offenses. National security crimes, very rarely. Hong Kong's national security law now presents a different challenge because we do have some very active measures of law enforcement in Hong Kong. In fact, even more active than in mainland China. So that's a different situation. But so what I usually tell people who ask my opinion about that, I think in theory, the risk is always there. You live in a world where there are authoritarian regimes. And if you offend them, they want to oppress you with or without law. So the risk is always there in this world of us today. But on the other hand, we have to have proportionality and we have a sense of pragmatism. The practical matter is that China, even though they have the law on the book, it is rarely enforced in practice.
Well, that's good to know. And on that slightly encouraging note, I think we'll have to call time on what has been, certainly for me, a fascinating conversation. Professor Ling, I really appreciate you joining us. It was hard to find a time we could do this since we're on literally the opposites sides of the globe, but I'm so grateful for the technologies that do allow us to have you be part of this conversation. And for everyone else, as we said, we're recording it. This talk and all the others in the series will be available on our website and our YouTube page. And we will be in due course producing some written materials in which we try to line up side by side what some of the different perspectives have been so that you can reflect on them and reach your own conclusions. So thank you all for taking part, and thank you so much, Professor Ling.